Okay, so good morning, everyone, and thank you for joining us for the second expert forum webinar of the PROTECT Consortium. This webinar is hosted by the Ryerson team in Toronto, Canada. Just a few housekeeping items before we get started. We would like to remind everyone that the session will be recorded. The recording has already started, and the recording will be made available through the PROTECT YouTube channel, hopefully in a few days. We also want to remind you to join the conversation on Twitter. So our handle is PROTECT.project2, and the hashtag we'll be using for today is Expert Forum. The other thing I would like to remind you is just to keep yourselves on mute so there's no interference with the presentation. We have already muted you, but in the event that it doesn't work, please just a reminder to mute your microphone. And the last item I would like to remind you about is the Q&A. So we will have a Q&A at the end of the session. Feel free to add your questions in the chat box. You can also add questions as we go along, but just keep in mind that we will take them up at the end of the session. So without any further ado, I will pass it to Dr. Idil Atak, who will present, or who will introduce rather our presenters. Thank you.
Thank you, Yona. Welcome to this expert forum. My name is Idil Atak. I'm an associate professor at Ryerson University in Toronto, Canada, and I have today the immense pleasure of chairing this event. This expert forum is part of a research project funded by the European Union. It's called PROTECT, the Right to International Protection, a pendulum between globalization and nativization. The project is led by Professor Hakan Sıcakkan from the University of Bergen and his wonderful team based in Norway. The vision of PROTECT is to discover ways of advancing international protection system within today's complex political context. The project consists of 11 universities in Europe, in Canada, and South Africa. I lead the Canada-related parts of the project, which is funded by SSHRC, Social Sciences and Humanities Research Council. I would like to thank SSHRC and European Union for their support. This event is part of 3 expert fora organized by the PROTECT team. And our aim is to take stock of the global compacts. We want to discuss current challenges of refugee and migrant protection in different contexts, including today in Canada. So I believe the topic is timely. As you may know, Canada is officially a global compact on migration champion country. The Canadian government has been involved in the so-called migration diplomacy. It's been eager to export its good practices and support other states' efforts on settlement and integration of refugees and migrants across the world. And the federal government has also promised to engage other levels of government, the provinces and municipalities in Canada in order to understand the extent to which existing practices are consistent with the global compacts. So today, our panel participants will explore some of these issues and discuss some of the challenges we observe in the field. This panel brings together distinguished representatives with different backgrounds, refugee protection legal field, civil society organization providing services to refugees, and grassroots movement organization advocating for migrants' rights, and UNHCR Canada. I would like to briefly present the speakers before leaving the floor to them. Our first speaker is Anthony Navanellen. He's practicing in the field of immigration and refugee law. He joined Legal Aid Ontario's Refugee Law Office in 2015, where he currently works as a staff lawyer. Anthony has appeared before all divisions of the Immigration and Refugee Board of Canada, and he represented clients at all levels of the federal judiciary, including the Supreme Court of Canada. Since 2014, he has served as a member of the National Executive of the Canadian Association of Refugee Lawyers, CARL, and Anthony currently serves as CARL's Vice President. Our second speaker is Max Scott from No One is Illegal, a major grassroots movement in Canada. Over his 20-year career working with immigration, Mag has accumulated several high-profile immigration cases in his arsenal. He has been able to support organizing around migrant justice and poverty using his immigration legal skills. The third speaker is Mary Jo Letty, a Canadian speaker, writer, theologian, and social activist. Mary Jo is widely recognized for her work with refugees at Toronto's Romero House. She has been active in human rights issues and the peace movement. She's an adjunct professor at the University of Toronto and an active member of the Ontario Sanctuary Coalition. Rana Han is our fourth speaker. She's head of regional office, UNHCR Canada. Rana is a human rights lawyer. She has been the UNHCR lead in Canada on judicial interventions, gender, children issues, and the global detention strategy. She has represented UNHCR in the Supreme Court of Canada on several landmark cases and has worked closely with the government and civil society partners to establish best practices on asylum, both regionally and nationally. Last but not least, it is also a huge pleasure for me to introduce my dear friend and colleague and our discussant today, Dr. Delphine Nakache, who is an associate professor at the Faculty of Law, University of Ottawa. She teaches courses in the areas of public international law and immigration law and refugee law. She has extensively researched and published on issues related to human rights and security-based implications of migration, citizenship, and refugee laws, both in Canada and Europe. Delphine is also a Canada lead for VALNR, another European Union-funded research project, and I'm thrilled that this webinar allows us to collaborate with our sister project of PROTECT. So I would like to invite Anthony Navanellen to take the floor. Thank you.
Thank you very much. So my name is Anthony Navanellen, and I am a staff lawyer at Legal Aid Ontario's Refugee Law Office. When I was asked to speak as part of the panel, the brief I was given was to try to explain or give some details of whether the Global Compact is filtering down into refugee decision-making here in Canada, whether we see it on the ground, both in terms of our clients' experiences in the board and in terms of the decisions we're getting from the board. And so that's the principal focus of my presentation today. I'm gonna just share my screen here because I have a slideshow that I am hoping to show you here. Can everyone see that okay? Yeah. I'm wondering if it's possible for me to, just wondering how I guess you can see the slides along the bottom, but that's not too to worry about. So my brief today is to ask, are we seeing the Global Compact on the ground in terms of how refugees cases are being decided in the country, how refugees are being treated in the asylum process? So just a quick brief on the organization I work for. I'll tell you at the start, of course, I'm speaking from my own personal experiences, and I'm not speaking on behalf of Legal Aid Ontario today. But this is a particular office I work at. It's a staff office within Legal Aid Ontario. And despite the name Refugee Law Office, its brief is a bit broader. It, of course, principally deals with cases involving refugee protection, but we also deal with deportation, humanitarian cases, and immigration detention. Refugee Law Office is located here in Toronto, and there are also satellite offices in Hamilton and in Ottawa. So in regards to the first big question, right, are we seeing the Global Compact implemented in decision-making and even in policy-making regarding refugees in Canada? The short answer to that, and the unfortunate answer to that, is no. And when I look and I ground that decision, I'm looking at a number of things. The principal decision-making bodies in this country in respect of refugee protection are twofold. One is the Immigration and Refugee Board, and they are deciding claims for refugee protection. And the second principal body is Immigration, Refugees, and Citizenship Canada. They are deciding what we call pre-removal risk assessments or applications for protection. That's the lingo for that. And the other group, of course, of decisions being made are the Convention Refugee Abroad or Country of Asylum classes. And those are, in shorthand, overseas refugee claims. People are being resettled to the country. The IRB is an independent tribunal, of course. IRCC is a government department, but in both of their decision makings, we're not seeing really any reference to the Global Compact. And for example, one place we can go to source that is CanLII is a public database of all IRB decisions and all federal court judicial reviews of both IRB and IRCC decisions. And there's not a single mention of the Global Compact in the entire CanLII database of those decisions, which is a bit surprising. Considering how much fanfare the Global Compact got, how much Canada indicated that it was going to become kind of a framework that it would be dealing with global migration, in particular asylum flows. So of course, that kind of begs the question, why hasn't this very important document filtered down? And in particular, it's a UN document, and traditionally, lawyers in particular are well versed at domesticating or taking a hold of those UN principle documents and translating them into legal arguments that can be made on behalf of refugees. And so why aren't we seeing that with the Global Compact? There's some theories that I have in particular. And the first place that we can kind of think or go to understand why we're not seeing it filtering down, of course, is the nature of the document. So the Global Compact bills itself as not a legal agreement. It's specifically not legally binding, but rather politically binding on the member states. And that makes it, to a degree, rather toothless in respect of the other kind of menu of international agreements that are available for refugees to use to ground their legal arguments before either the IRB or the IRCC. And of course, the principal documents we're talking about here are the 1951 Convention and the Protocol, the Convention Against Torture, the Convention on Civil and Political Rights, and the Universal Declaration of Human Rights. Now, the IRPA that's the Immigration and Refugee Protection Act, that's our framework legislation here in Canada, is really well suited to help lawyers and claimants that they're representing domesticate broader international agreements into their domestic legal arguments. The principal mechanism for that is Section 3, Sub 3F of the Immigration and Refugee Protection Act. And that specifically requires that the act be construed and applied in a manner that complies with Canada's international human rights instruments. But the problem is, of course, the Global Compact is not necessarily a international human rights instrument, right? It's a political document, it's a policy document, but it doesn't create legally binding obligations on states. And therefore, it can't be domesticated through Section 3.3F of the IRPA. Another place you can go to as a mechanism for domesticating these type of international agreements is the Baker decision from the Supreme Court. It's a bit narrower than Section 3.3F. It says that you can use agreements that have been both signed and ratified by Canada to help kind of guide discretion under the Immigration Act. Section 3.3F is a bit broader. It says, documents that we have signed, even if we haven't even ratified them, can be used to interpret the act. But unfortunately, because the compact is not a legal document, we can't use those mechanisms to kind of bring it down to the ground level and use it as a tool to advocate on behalf of our clients. It is strictly a soft law instrument. And in the menu of soft law instruments out there, there's many far more immediate instruments that are probably much more practical to claimants. And those include things like the IRB's guidelines on things like vulnerable claimants, gender-based claims, sexual orientation, and gender identity-based claims. So if I'm a lawyer and I'm looking around for soft law instruments to help persuade a decision maker, it's very unlikely I'm going to go to this high-level instrument like the Global Compact when there's far more immediate and I'd say more relevant documents that I can use on behalf of my clients. So we're not seeing the compact in terms of decision making, but curiously also, we're not seeing it necessarily domestically in terms of policy either. So if you look at things like even the IRB, the Immigration and Refugee Board website, there's no mention of the compact whatsoever. But even on IRCC's website, and that's the government's own department dealing with migrants and refugees, there's only 3 really dated references going back to 2018 that directly reference the Global Compact. So it's really even absent from the government's website dealing with these communities, which is a bit surprising. And even more so is that there have been a number of significant policy announcements regarding refugees from this government in the past 2 to 3 years when the compact has been in place. And they dovetail to some extent with the commitments that are made under the compact, and yet there's no direct linkage being made by the federal government to the compact in rolling out those announcements. So things like the 2019 and 2020 federal investment into refugee legal aid. Some of you may know in 2018, the provincial government here in Ontario, which receives almost half the refugees in Canada, withdrew funding from legal aid involving refugee issues, created a big crisis here in the province, and the federal government stepped in to fill that economic kind of hole, both in 2019 and again in 2020. And that dovetails really well with the paragraph 61 commitment for fair and efficient determination of refugee claims. And yet there's no linkage made by the government to that commitment. Same with the National Immigration Detention Framework, dovetails almost exactly with paragraph 60 of the Global Compact. And yet we don't see any mention when they roll out the National Immigration Detention Framework and the year-on-year funding that it has, because it does have 135 million over 5 years, no connection to paragraph 60, which talks about community-based alternatives to immigration detention, reducing detention of minors, which are the exact same goals as the National Immigration Detention Framework. So it is a bit puzzling why, I think maybe at a decision-making level, it's not so surprising. I've given you some reasons why we're not seeing the Global Compact being used by lawyers and being used by the claimants they represent. A bit more puzzling why we're not seeing the Global Compact being used by government, though, to kind of reinforce the policies they're pursuing. And that kind of raises the next question that I wanted to address, and that is maybe a bit of educated guesswork about why we're not seeing the Global Compact being used more in terms of refugees that are here in Canada. And part of that surprise is that Canada's leadership on refugee issues is a big central plank of the Liberal government's branding of the country, or rebranding, they would probably say. And it's tied to big international goals Canada set for itself, like getting a UN Security Council seat. And you would think that trumpeting the Global Compact would easily lend itself to these other larger foreign policy goals of Canada. And so why aren't we seeing it more used domestically? I think there's a number of reasons, and there's three I kind of really wanted to focus on, but they all kind of can be explained, I think, by this chart. And this chart is the number of inland asylum claims that are happening or being received by Canada. And institutionally, as far as the government is concerned, they don't really look beyond 2012. They're looking at the trend from 2012 onwards. And if this trend continues, we don't have 2019 on the graph, but you'll see the number there is 64,000 claims here in Canada, which would put the bar even off the graph there. And the government, fair to say, is alarmed by this graph, right? And they don't have a pretty strong institutional memory when it comes to the alarm, because we've had similar rises before, and in particular in the 1990s, we were facing very similar numbers of claims. There was nothing unprecedented about these numbers, but the government feels there is. And the government, certainly, there's a lot of rhetoric out there, and in discussions with ministers, you hear the same line, that they feel the Inland Protection Program, and that's what we call the program to deal with asylum claimants who arrive on Canadian shores to make claims. They feel the Inland Protection Program is not sustainable. And if this trend continues, Canada won't be able to process those claims in a fair, and most importantly for them, efficient manner. And so Canada has been reaching out to find solutions to how to reduce the number of inland claims. And I think that's pretty fair to say one of the main principal planks now of the government. How do we reduce the number of inland claimants who reach Canadian shores? And so that first bullet there is just talking what I said before. When it comes to refugee policy, the goal here is to reduce inland claims. And the concern, of course, is that while Canada is signing on to the Global Compact, for certain, many elements of that are purely humanitarian. They're motivated by Canada's genuine interest in finding durable solutions for refugees, and ensuring proper management of refugee flows. But at the same time, I think while there's Canada the good out there, and that's the Canada that we see who's pursuing the UN Security Council seat and all those other measures, there's also the Canada not so good. And that is, as I said before, Canada's really deliberate policy attempts to prevent inland claimants from reaching Canadian shores. And the concern is that the Global Compact, while it certainly is motivated by very good intentions, can be easily co-opted into that agenda. And we see examples of that where the language of the Global Compact and even some of its objectives have been used by Canada, not necessarily to assist migrants internationally, but maybe at the same time or principally to prevent those migrants from reaching Canadian shores. And so to that extent, the Global Compact is not necessarily a document about how Canada should treat its own refugees who are in the country. It's more a document about how we treat refugees abroad that dovetails with the goal of not making sure they reach or ensuring they don't reach our own shores. So one of the goals here, of course, is to externalize refugees. It's to prevent refugees from reaching the shores. Here, principally, this was done, of course, through visas, and the visa tool is eroding really as a tool for proper refugee management in Canada. Part of that is diplomatic pressures from other countries. So, of course, we used to have visas on top refugee-producing countries from the European Union, Hungary, Bulgaria, Romania, Czech Republic. And due to a lot of pressure from the EU and as a condition of the Canada-EU Free Trade Agreement, those had to be phased out. Same with the visa that was imposed on Mexico, that due to tremendous pressure from Mexico also had to be phased out. And so there are new tools that come in to replace those, like the electronic travel authorization that even visa-free passengers have to obtain. And part of the goal of the electronic travel authorization is to make sure we screen out refugees. There's also direct interdiction, for example, CBSA officers who are stationed in Europe, airports in Central and Eastern Europe, who pull so-called Roma-looking persons out of line for additional questions and then cancel their electronic travel authorizations on the spot. But the new tool, and the tool that really is pioneered by the European Union and now adopted by the US more, is the use of third countries as mechanisms to absorb, or perhaps in some cases even just blatantly block refugee flows. We see that, of course, pioneered with the European Union with their Mediterranean strategy, in particular the EU-Turkey migrant deal. The US has now replicated that with its asylum cooperation agreements with the countries in the Northern Triangle last year. And the goal of those, of course, is to stop refugees from coming to Canada by employing other countries as, to some degree, sponges to soak up refugee flows and to ensure that refugees are, in some respect, either legally stopped there because they are properly able to claim protection and integrate, and so they have a durable solution in that third country. And perhaps the more extreme examples, in particular, we see it with the EU policy, and I think the asylum cooperation agreements, just really bold attempts to kind of block refugees there and say, look, you have a durable solution, even if it's not actually the case, and therefore we don't need to hear your claim once you come further. So this language of capacity building and technical training that is just filtered throughout the Global Compact can be very beneficial, but I think we have to be very carefully aware that there is another side to that coin about what the motivations are for countries like Canada for pursuing those goals, and that is, to some extent, to create these buffers in regional countries that will absorb and block refugee flows that would otherwise be continuing on to Canada. The other big plank or big idea behind the Refugee Compact is the idea of burden sharing. And we hear that language a lot in the Global Compact. This is about international burden sharing. Global migration is a global problem, needs a global kind of management or solution to it. And that's a great idea. And I think initially the idea of burden sharing is that rich countries should be able to share their expertise, in some cases their funding, to help less financially able countries deal with those flows. But the problem is, though, is that we see that language used to really help rich countries keep refugees out of their borders. And that language of burden sharing, we see it in terms of old policies that are now explicitly being defended in court based on the idea of international burden sharing. And the best example of that is the US-Canada Safe Third Country Agreement. That's the agreement that bars migrants who have transited through the United States to our border, land border, from entering the country to make a claim here. It was recently struck down by the federal court, and there's a citation on the slide, but it's now under appeal at the Court of Appeal. And the government, from A to Z, argued that this is an effective tool of international migration management, and it's essential to Canada's maintaining of the inland protection scheme, but also situated in terms of global efforts to properly manage migration flows. And so it's a real turning on its head, because it's not the kind of burden sharing where it's about helping poorer countries manage flows. It's about keeping refugees out of richer countries. The same policy animated the new ineligibility provision that was introduced by the federal government in 2019 in the Budget Implementation Act. And there's a section there, the Immigration and Refugee Protection Act. It says that if a refugee has made a claim, even if no decision was made on it, made a claim in Canada, the US, Australia, or New Zealand, they are ineligible to pursue a claim here in Canada, even if no decision was made on the claim in the other 4 countries. And once again, that was billed as proper global management of migration flows, ensuring no secondary movements, no so-called asylum shopping. And so that language of burden sharing has been adopted by Canada in ways that I don't think was necessarily contemplated when it was kind of made a central plank of the Global Compact. And so I think we should be very careful in how burden sharing is deployed as a rhetorical tool. And lastly, I wanted to talk about resettlement, because there's a large focus on resettlement within the Global Compact. Resettlement is a fabulous plank of international refugee protection. It is a great durable solution, and Canada, I do not want to dispute, is an international leader in resettlement. But the problem is that the government is increasingly playing resettlement off the inland protection scheme. And I'll talk more about these 2 photos before, but there's a dichotomy emerging both in how the government describes refugees and really how they're treated between so-called good refugees and bad refugees. The good refugees are those who wait overseas in camps. They are selected, hand-selected by the Canadian government. Their claims are decided abroad, and if they are granted, then they are allowed to come to Canada, and that's the resettlement process. And that, the best example of this, of course, is Prime Minister Trudeau welcoming the Syrians in 2015, 2016. Lots of fanfare about that, lots of media attention. The bad refugees increasingly are those who are billed as queue jumpers, increasingly labeled as bogus refugees, and those are the ones who show up at our border, jump the so-called queue, although there is no queue, and increasingly, in terms of irregular crossers at Roxham Road, are just labeled as illegal migrants. And so that's kind of the last theme of the Global Compact that I think we have to be very careful about. Because we are seeing that dichotomy emerge. And especially during COVID, the government has effectively closed the US-Canada border to refugee flows. There's been tremendous criticism of that. And the government has consistently said, we recognize that criticism, but don't worry, we're going to increase resettlement numbers. And so there's this playing off of keeping out inland claimants, but trading it off against resettled refugees. And there really shouldn't be a trade-off. Both groups are at risk. Both groups are entitled to international protection. And yet that language there between the good refugee, the resettled refugee, the one who waits overseas, versus the so-called queue jumper, the illegal crosser, is very problematic. And even within the framework of resettlement, there's been, I think, a shift, and a very disturbing shift, away from a focus on the most vulnerable. And that's traditionally been the rubric Canada uses. The most vulnerable refugees are prioritized for resettlement. During COVID, of course, we saw a massive drop in immigrants to Canada, people who are voluntarily coming here. And immigration is the fuel for the Canadian economy, and the government is in kind of a panic about the low immigration numbers. And you're seeing this idea of what's called a refugee skills, or tapping into refugee skills abroad, which is the Canadian government is talking now about, can we go to refugee camps and identify within the camps people who have skills that would be a benefit to the Canadian economy? That is a completely different way of thinking about resettlement, about who is entitled to resettlement, who gets prioritized. So even when we're moving away from inland protection to resettlement, within resettlement, we're moving away potentially from the focus on the most vulnerable to now who are the most skilled. Now that focus that second part has not actually happened yet. The government's still talking to stakeholders about it, but it is very troubling. So that's my presentation for today. Big picture, we're not seeing it in domestic decision-making. We're not really seeing it in domestic policy. And at an international level, I think the reason for that is that I think the Canadian government sees the Global Compact as an external document. It's about how to manage refugee flows abroad, as opposed to how do we treat refugees here in Canada.
Thanks a lot, Anthony, for this overview and highlighting some of the issues we observe in Canada. I would like to invite Mac Scott from No One Is Illegal. Mac, the floor is yours.
It's always hard to follow Anthony. He does a very, very good job. The one thing I would just add to what Anthony said is that I think we have to take this in, when we're looking at this in a global context. Egypt, Jordan, and Lebanon host over 1 million refugees every year. Canada's resettlement numbers are usually in the 10 to 20,000s. I don't think we've ever even done 20,000. Anthony would probably know better than me. So within a global context, we are falling far short, despite the fact that we, and particularly Justin Trudeau, laud ourselves on our refugee system. And I think, within a global, within the idea of the compact, we are falling far short on trying to take some of the burden off the global south, which hosts by and far the majority, the large majority of refugees in this world. I was just going to talk about 3 problems that I've worked on within our refugee commitments here in Canada, and hopefully this will be helpful. The first is detention of migrants and refugees. The second is our dealing with stateless refugees and migrants. And then the third is our cessation policies within our refugee program. On the detention one, I wanted to open by quoting James Hathaway, who is probably one of the largest experts in the world on refugee policies. And it was in the foreword of the International Human Rights Program at the University of Toronto Law School report, We Have No Rights, which is about arbitrary imprisonment and cruel treatment of migrants with mental health issues in Canada. And this is what James has to say. There is tragically nothing new about the propensity of states to treat migrants as beyond the bounds of the rule of law. Writing the callousness that often met refugees and stateless persons forced away from their homes more than half a century ago, Hannah Arendt identified the germs of a deadly sickness. For the nation state cannot exist once its principle of equality before the law has broken down. Without this legal equality, the nation state dissolves into an anarchic mass of over and underprivileged individuals. Laws that are not equal for all revert to rights and privileges, something contradictory to the very nature of nation states. In this important study, authors Hannah Gross and Paloma van Grol and our editor Renu Mantuhan shine the light of day on a contemporary manifestation of this callousness. The detention by Canada of thousands of persons every year, a substantial number of them in common jails. Beyond its truly massive scale, the study shows that migrant incarceration by Canada often operates in something approaching a legal black hole, for example. That key decisions, including the decision to detain in a provincial jail, are made without a legislative authority. And actually, Anthony's worked on a number of these cases, as have I, trying to change this. So immigration detention in Canada, I'm going to go into numbers in a minute, happens to both migrants and to refugees. And it's dictated by sections 55 and 248 of the Immigration Refugee Protection Act, which Anthony was talking about. And basically the deal is that if you come into Canada as a foreign national, or in some occasions as a permanent resident, and they decide they can't identify you, or that you're a danger to the public, or that you're not likely to show up for hearings for removal, then they can detain you. If they decide there's a ground for detention, then they later look at 6 different factors under section 248 of the regulations, only 2 of which are related to the length of detention. So basically, it's an extraordinarily arbitrary system. Also, the initial decision to detain is made by an officer without any, court, without any oversight whatsoever. Canada Border Services Agency, which is Canada's immigration enforcement, has no oversight body. And then it's reviewed by a tribunal, which is not even a formal court. It's an administrative tribunal. In 2018-2019 fiscal year, Canada detained 8,781 people for an average detention of 13.8 days. 31% of these were held in maximum security facilities. So these are like the jails you see on TV, orange jumpsuits. lockdowns, all that kind of stuff. 439 were held for identity reasons, and usually the people being held for identity reasons are refugee claimants. People who show up with ID that in our Western world we don't recognize as being valid. Or we have a belief that a certain country, usually based, I hate to say it, on racism, produces a lot of fraudulent ID. In 2018, 2019, 118 children were held, an average of 18.6 days, and that doesn't include children that are housed. And one of the ways they get away with saying that they're not detaining children is that if they pick up parents and the parents have nowhere else for that child to go, then the child is kept with the parents, and that is called housed as opposed to detained. So that 118 doesn't even include the many children who are so-called housed, and being in jail sure looks like you're being detained to me, whether you're being housed or you're being detained. In the eastern region, which is Quebec and the East Coast, identity is a major ground used to detain. And actually, this has been addressed by a number of groups in Quebec, in Montreal and other areas. And 1,949 were detained on identity reasons in the 2018-2019 fiscal year in the eastern region. And these stats are all from the Canada Border Services Agency website, which I can post in the chat if people want to check them out. Now, I'm going to give you an example of a client of mine who was a refugee claimant and was detained, because detention is particularly onerous on refugees. And I'll explain why. So this client, I won't give you his name. He came in from Mexico. He was a political activist in Mexico and very much in danger in Mexico. They detained him on entry on the basis of an old outstanding charge in the United States that because he was being detained on danger grounds due to the criminal charge, he was held in the Toronto West Detention Center, a jail that's since been closed down because it was so out of date and such a terrible place. He was detained there. While he was there, he got tuberculosis. He got TB because TB was rampant in the jail. This meant that his refugee claim was put on hold for 2 years until he was able to get rid of the TB. In the meantime, we had to prepare his case. We had to prepare his basis of claim form, which is a thick form that basically forms the foundation for a refugee claim. We had to do all that through glass, sitting in a jail with me visiting him. And it's difficult enough. Well, I just have to say, at a refugee hearing, even though, again, that's also an administrative tribunal, there's a high expectation for production of evidence. Even though they're supposed to assume that your case is true, unless shown otherwise, it's the opposite is really the truth. And gathering that evidence from another country is hard enough in normal circumstances. Getting it when you're in a jail is almost impossible. But it doesn't matter. They're still going to expect it when you show up for the hearing at the Refugee Protection Division. And then I just went on detention to talk about, well, I want to invite you all to a demonstration that's coming up, though we don't have it scheduled yet. But we recently had Ibrahim Touri was re-detained. He's a person that we did a habeas corpus for and got released after 6 years of detention. He was re-detained. He was released yesterday. And he was detained because basically he missed an appointment. And that was why they detained him. So you're talking about an extremely arbitrary system. We're right now trying to go before the Supreme Court in the case of Alvin Brown and End Immigration Detention Network and Canada, around trying to get Canada to do what many European and other countries have done, and which is actually part of international law. And the United Nations Working Group on Arbitrary Detention has condemned Canada for not having this, which is to have what we call presumptive period. It's a period of time, usually 90 days or 6 months, after which you have to release someone unless you can show that there's absolutely a foreseeable date that they'll either be released or removed. So we're trying to bring that to the Supreme Court. We just applied for leave last week, and hopefully we get that before the Supreme Court. And it's very much based on international law. As Anthony pointed out, cases like Baker and also the Guzman have made it very clear that Canada international law is interpretive of the Immigration Refugee Protection Act. We're saying that if you're going to comply with international law, and again, the United Nations has said that we are not complying, on at least 3 different occasions, then we need to have such a period. Then how's my time? Sorry, am I going too long?
You can take 5 more minutes, Mark, if that's okay.
Maybe I'll just deal with the statelessness stuff then, and not the cessation. So as Anthony quoted Baker and I quoted Guzman, and in de Guzman, what the court actually said is, first, the words shall be construed and applied in a manner that complies with international law are mandatory and appear to direct courts to give the international human rights instruments in question more than persuasive or contextual significance in the interpretation of the IRPA. By providing that the IRPA is to be interpreted and applied in a manner that complies with the prescribed instruments, paragraph 3F, if interpreted literally, makes them determinative of the meaning of the IRPA in the absence of a clear legislative intent to the contrary. Which obligates us to afford stateless persons certain rights. It obligates us to issue identity documents, which is in Article 27, issue travel documents, Article 28, to not expel such a person, Article 31, and generally to afford them the same treatment as a national. In the absence of a program to the contrary, this should be construed as an obligation to confer permanent residency status under Canadian immigration law to stateless people. Despite this, Canada has not ratified the United Nations 1954 Convention relating to the status of stateless persons. As a result, we actually have no program for stateless people. A stateless person can only avail themselves of Canada's protection if they face a risk of persecution and make a successful refugee claim, or risk their life, or of torture or cruel, unusual punishment or treatment, which makes them a protected person, and again, they have to prove it, in their country of habitual residence. So even if my client can't be returned to Jordan because they got one of those older passports that Jordan issued to Palestinians, which expire after 2 years and can't be renewed, my client still has to make, or the person still has to make a refugee claim against Jordan, against a country that they can never be removed to. The most recent stats I could find were from the Canadian 2016 census, which said that 3,790 people identified themselves as stateless when asked to select their country of citizenship. Of this, 390 indicated that they did not have permanent resident status in Canada at the time. Official figures from Immigration, Refugees, and Citizenship Canada show that there are 316,882 stateless permanent residents in Canada since 1981. And this is from the document stateless, and this is from statelessness.ca, which is an excellent website, by the way, and deals very, very thoroughly with the issue of statelessness. If I have another minute, I'll just really quickly touch on cessation. So another way, Canada, as part of the Global Compact and other international law, is not allowed to refoul, is not supposed to refoul, which means not send someone back to a country where they're in danger. However, we have, under Section 108 of the Immigration Refugee Protection Act, we can take away someone's refugee status and then effectively send them back to their country and basically refoul them. And one of the worst parts of this is that there's 5 different reasons why you can have cessation, and one of them is that the reasons for which the person sought refugee protection have ceased to exist. So this means that suddenly there's a change of government in your country of origin, you're a refugee or even a permanent resident, I'll get into that in a minute, then you are basically sent back to your country of origin. And this is according to Section 40.1 sub 2 of the Immigration Refugee Protection Act, which states that a permanent resident is inadmissible on a final determination that their refugee protection has ceased for any of the reasons described in paragraph 108. So even if you're a permanent resident, you can lose your refugee status and be sent back to your country of origin. And that was adopted in 2012. So there are many other concrete ways, and I'm sure that Mary Jo will get into them. She's been doing this longer than I have and is much more of an expert than I am. But there are many ways that Canada falls afoul of international law and its obligations under international law. And this is despite, as Anthony put out there, and as de Guzman and also Baker state, that our laws should be in parallel to international law. And when it comes to the Global Compact, it actually isn't surprising that we don't mention it in any case law, because frankly, we just don't follow it. And thank you. And just check out, I'll put our website in the chat, but we're doing ongoing work in Toronto through No One Is Illegal to try and fight for changes in these laws.
Thanks a lot, Mark, for this very informative talk. Now I'd like to invite Mary Jo Leddy. Mary Jo, the floor is yours.
Thank you. And Mac, I apologize. I missed the first half of your talk with a bad connection.
It's okay, it was boring.
I assumed that we were going to have some wonderful experts speaking in detail about the Global Compact. So I would like to speak quite briefly on the underlying dynamic of the relationship between seeing refugees as a threat or seeing them as an opportunity. And if I go back 30 years ago, when we were starting Romero House, we bought a house or two with a huge mortgage in a small middle-class, no-name neighborhood. And the neighbors spent 2 years trying to get us out. It was a NIMBY reaction, that we were going to have refugees, that they were going to be selling drugs, there would be prostitution, and all of the property values in that neighborhood would go down. So that was our first introduction to refugees as a threat. And my lesson is that it took almost 15 years for that to turn around, where refugees were seen not as a threat, but as good neighbors, as a wonderful asset. We now have a dynamic neighborhood with a street party with hundreds of people. And I have wondered sometimes in the course of this experience, what is it that turned that around? And my first lesson, regrettably, is it took such a long time. It doesn't happen the way we write about it in the books or articles. It doesn't happen overnight. And in that process, I think we also have an opportunity to learn from the refugees themselves about what hospitality means. Many of them have been part of the process of finding safety for other refugees. And they also know how long it takes. So when we began the work for refugees, in addition to being with people in a neighborly way, I also wrote a book about our communal experience together in the neighborhood. And after the book was being published, my publisher said, "You have to go on a book tour." This is before Zoom, and people did that kind of thing. You wrote a book and they sent you across the country and you were supposed to sell the book. So they said, "And you're going to go out west, you're going to go to Manitoba and Alberta and BC. Isn't that great?" And I said, "They'll kill me. They will. I can't go to Alberta. And I had this stereotype that all Albertans wore cowboy boots and were against refugees. But I had to go, so I went. And I remember distinctly, among other experiences, being on a radio program, and the first half hour of that program, people were yelling and screaming the same way that our neighbors had done so in Toronto. Refugees were not an opportunity, but a threat. And that particular radio show turned around when I told them the story of one refugee. And immediately the telephone lines lit up and people called in and said, what can we do? And so the threat became an opportunity. And I've never forgotten that. The first being, I have to presume that most people, when faced with the suffering of another, want to do something. And I think that's where we come in, where we can make suggestions about what people can do. Now, fast forward 30 years later, I began to realize, I give talks across the country, write books, but I began to realize that the situation was changing. If you remember, in the past election, the People's Party put up a billboard that was very inflammatory, very anti-refugee. And immediately, hundreds of people phoned the billboard company. And within days, billboards were all taken down. People, hundreds of people apparently, spoke up and said, this is not true. We object to this image of refugees. And I began to think that we aren't just in the same old situation, and that something has happened in this country, and I attribute it to the refugee sponsorship program. And I called some people in preparation for this talk. I called some people who work mostly with sponsored refugees, privately sponsored of a group. And their calculation is that since 1979, since the arrival of the boat people and the beginnings of the sponsorship program, Canada has sponsored 275 refugee families. It is almost a drop in the bucket compared to a place like Lebanon or Egypt. But it's 275 refugees who can now speak for themselves, most of whom are Canadians. And if we divide that number by 7, we could say that there are now 40,000 groups of people who have at least met a real refugee, who at least know them somewhat. And I think, to borrow a phrase from political theoreticians in the world today, this is a base. 40,000 communities, groups that have sponsored refugees, meaning they raised the money to bring them here. They worked together. They've they know them, they know their ups, they know their downs, that they are refugees are people. And I think this is extremely important, that people who work with refugees now have a base. And we need to draw on that base. We need to know there are people in our country who are refugees, been through the refugee experience, and there are thousands of them. And perhaps what we are doing, hopefully, is to amplify those voices that call us to be part of a compact and to take responsibility and to begin to treat refugees as people who are an enormous resource for this country, a great natural resource for this country. So I won't go on. There are other speakers that we'll want to hear from, but I want to note, going back to Andrew's talk, that while we often have a great language about refugees, and we pat ourselves on the back, and sometimes that's really true, but many times it's not. And I think the most glaring example of that has been the response of the Canadian government to the Safe Third Country Agreement. Single in a stroke of the pen, and I remember going down to the border the day that it closed, and the door was shut on the way that at least 2/3 of our refugees had come to this country. Because they were seen, the Safe Third Country was not an American invention. It was something we cooked up. And Andrew explained it very well. We have devised ways of keeping people out while speaking eloquently about what we have been doing. I want to just close with one example of the way, in addition to the third country, one example of how we not only keep people out, but keep them down. And it would be the way in which government bureaucrats have designed the various application forms. And one of the simple forms that most refugees have to fill out is a work permit. And you would think of all the application forms that they have to fill out, that a work permit would be the simplest. It would be something that we would want for everybody. The ability to work, contribute, and support yourself. And yet, in my experience, every day at our Romero House office, we have many people come. And the only purpose they come to our office is to say, please help me with this work permit. It is so tricky. It is so obscure. People can't just work. They have to find out how to fill out this enormously tricky form. It's trickier than a citizenship application, than the application for permanent residence. So I think I'll just close for now. This over to the next.
Thanks a lot, Mary Jo. Thanks for highlighting this example that highlights some of the challenges faced by refugees, but also underlining the importance of the refugee sponsorship program in changing the narratives, negative narratives against refugees, and also the mobilization by refugees. Hearing refugees' voices are critical in terms of advocating for themselves and changing the narratives. Thanks. I would like to invite Rana Khan from UNHCR Regional Office. Rana,
Thank you so much. Thank you very much, Idil. Thank you very much for inviting UNHCR to this important discussion. And thank you to all the speakers who have come before me this morning for their eloquent and important contributions to this discussion. I'm just going to now sort of go into my speaking points, and I look forward to the discussion after. Despite these challenging times and amid unprecedented number of persons in need of protection globally, there is a counterbalance to the shrinking asylum space, an intrinsic value of providing protection to those fleeing persecution that has withstood the test of time. It is one of humanity's longest standing traditions, a shared value found in many religious and cultural traditions and now entrenched in international law. The right to seek and enjoy asylum is provided in the Universal Declaration of Human Rights, as we've heard, and it is a binding obligation on states who have signed on to the 1951 Convention. This value was asserted and adopted most recently by over 152 states in the Global Compact for Refugees in 2018, and all 193 member nation states in the New York Declaration on Refugees and Migrants adopted in September 2016, reflecting a strong reaffirmation of the fundamental principle of refugee protection. And it has found deep expression in Canada, which has itself a long history of welcoming newcomers and refugees. Besides the legal obligation to provide protection for states who have acceded to the convention, there is a strong record attesting to the fact that providing safe haven is an opportunity for the refugees to get safety, stability, and the ability to make a new start, and for host countries to get new talent and skills, fresh ideas and perspectives, and future citizens. A record 79.5 million people have been driven from their homes by a spate of new conflicts and by old ones that rage on, and political solutions are in short supply. A handful of countries, some among the poorest in the world, have borne the brunt of what is really a global responsibility. And too many refugees have had their lives put on hold, confined to camps or to a hand-to-mouth existence, unable to flourish or contribute to communities where they live. Refugees who are included in society, who can learn and work, who are able to provide for their families in exile and contribute to their host countries. And this needs to be recognized and implemented. There was a widespread global recognition of why we need to change the way we respond to forced displacement. The New York Declaration recognized that an issue as far-reaching as forced displacement, no single actor can operate in isolation. Transforming the response to meeting forced displacement today needs a more diverse coalition of support and action, from government, development organizations to civil society to business communities. Partnership is the key to achieving a better deal for refugees, and their hosts all have a key role to play. The Global Compact on Refugees presents a vision for better dealing with refugee situations worldwide, to chart a new, more sustainable way forward, a new deal for refugees and the communities hosting them. The basis for the Global Compact for Refugees is for predictable and equitable burden sharing and responsibility sharing among UN member states. The purpose of the program of action is to facilitate application of a comprehensive response in support of refugees and countries, particularly those affected by large-scale refugee movements or protracted refugee situations. So it calls for a number of measures at the global, regional, national levels that states and others can take to better support host communities and to ensure that refugees can thrive along their host countries. The Global Compact on Refugee has 4 major objectives, which include easing pressure on refugee host countries, enhancing refugee reliance, expanding access to third country solutions, and supporting conditions in countries of origin for return in safety and dignity. I wanted to take a moment to just give a little bit of background on Canada's engagement on the Global Compact for Refugees. It contributed to the negotiation of the Global Compacts prior to the adoption of the New York Declaration in collaboration with several countries, and was actively involved in the drafting of the Global Compact and endorsed the partnership approach that was adopted. Leading up to the negotiations for the Global Compact on Refugees, Canada engaged domestically with civil society when drafts were developed and advocated for the inclusion of gender-sensitive language and recognition of specific needs and capabilities of women and girls, and in advocating for inclusion of concrete practical actions in the Global Compact for migration that reflects the views of civil society, including migrants themselves. In July, it became the co-chair of the annual tripartite consultations on resettlement, a forum for national government, civil society, and UNHCR to collaborate, discuss, and shape joint strategies on refugee resettlement issues. It pledged support for the creation of a new global task force on refugee labor mobility. The overarching goal of the global task force, which will be launched later this year, is to generate global momentum to scale up labor mobility pathways as a solution for refugees. In 2021, the Immigration Citizenship Canada will continue sharing Canada's best practices to assist other countries in improving their migration systems, including through participation in the regional Global Compact on Migration follow-up that took place in 2020. Canada continues its migration diplomacy efforts through the Global Refugee Sponsorship Initiative launched in 2016 to build community refugee sponsorships globally. In 2019, the Global Refugee Sponsorship Initiative founded an international coalition of states dedicated to sharing best practices around global sponsorship, refugee sponsorship globally. In line with the Global Compact on Refugees recommendation, Canada has made efforts to promote refugee participation. It established an advisory role for a former refugee to attend international refugee protection meetings with the Canadian delegation to provide their perspective to policy development and engagement. It has also established a refugee advisor network. And in the spirit of Global Compact, a refugee whole of society approach, measures are being taken to ensure that local actors and cities are directly engaged in developing and implementing strategies for comprehensive refugee responses, direct city-to-city collaboration, and learning for further support to better integrate refugees hosting within these communities. So, but opportunities also present challenges, especially in times like the ones we are living in. I just wanted to highlight a few to sort of balance out the background that I've just mentioned. For example, the temporary closure of the borders. In the global context, 167 countries have so far fully or partially closed their borders to contain the spread of the virus. At least 57 states are making no exception for people seeking asylum. In this extraordinary time, UNHCR recognizes the need for states to take public health measures to protect their populations. At the same time, UNHCR has stressed that such measures can be taken in a manner which allows access to asylum for persons in need of protection, and that these measures need to be temporary and not extended any longer than necessary. The right to seek asylum can and must be upheld even during a global public health crisis. UNHCR has called and continues to call on all states to manage border restrictions in ways that also respect international human rights and refugee protection standards, including through quarantine and health checks. We understand the imperative to protect Canadians in these uncertain times. However, in Canada, as elsewhere, UNHCR has advocated for any border measures to respect the right to claim asylum. There are other preferred measures to mitigate health concerns, such as health screening and quarantine arrangements, which are also being used. We have also emphasized that the agreement should be temporary. It is vital that any restrictions are maintained only for as long as necessary, and that state commitments to international refugee and human rights are not weakened. Due to the pandemic, asylum processes have also been affected. Some states have totally put on hold their asylum procedures, and others have adjusted to ensure continuity. The delays do affect persons in the system, such as eventually just the ability to get a job, ability to be reunified with their families, and capacity for integration, which is also delayed. And it also has implications for the system, such as growth of backlogs, and impacts not only on the refugee processing part, but also in accessing of work permits and other opportunities for asylum seekers. Here we can draw experience from other states which have developed remote ways of conducting refugee status determination and other good practices of extending documentation long distance, and share those practices. And UNHCR as well offers technical and financial support in countries where it is needed. And we know that in Canada, there has been some adjustments to the process and flexibilities built in at the Immigration and Refugee Board to deal with the exceptional circumstances that we are under. With respect to detention, the challenges have also provided an opportunity to do things differently. For example, the number of persons in detention has decreased nationally this year significantly, and the release through the use of alternatives to detention has increased as well. And I just wanted to end by highlighting some opportunities and some programs that Canada is pursuing under the Global Compact on Refugees. Canada is taking specific initiatives to increase resettlement capacity and complementary pathways for refugees grounded in labor, education, and family reunification outcomes. It will establish a new multi-year resettlement commitment starting in 2021 and will continue to support the resettlement of women and children who face heightened protection risks due to their gender. The WUS program, which is an organization that is an official sponsorship agreement holder with the Government of Canada and supported by the government, mobilizes individuals, schools, and businesses to resettle refugees through education and employment pathways, and works with 15 countries in Asia, Africa, and the Americas. The government recently announced a commitment to expanding complementary pathways for refugees, including launching the second phase of the Economic Mobility Pathways Project, which helps qualified refugees connect to labor mobility needs through immigration programs. The EMPP programs, the objectives are to ease pressure on host governments to expand third country solutions for refugees, enhance self-reliance, and build capacity for refugees to themselves to attain a durable solution. It is in addition to the traditional resettlement pathways and is part of the immigration program of the government. Through the EMPP, candidates can apply for permanent residence through existing economic immigration pathways, such as the Provincial Nominee Program, the Atlantic Immigration Pilot, and the Rural and Northern Immigration Pilot. The Global Compact on Refugees remains applicable even when the pandemic is creating an international protection crisis. The pledges made at the Global Refugee Forum are a starting point and need to be translated into action. They have begun, but a lot more work needs to be done, and it needs to be done in partnership, in collaboration, and with the support of all involved in this global refugee issues. Thank you so much.
Thanks a lot, Rana. Now I would like to give the floor to Delphine, who is our discussant today.
Yes. Hello, everyone. Can you hear me okay? Wonderful. So thank you very much, first of all, to all presenters. I see some common themes, certainly, made through the presentation. So just a few comments, and hopefully this will allow for more conversation. But what I found really extremely interesting is that all presentations, in fact, share something in common. They allow us, and I think it's important for an external audience, a non-Canadian one, I would say, to really provide a more qualified image regarding Canada. Canada always is seen as a very positive, as a very strong country in terms of its with very positive treatment towards migrants and refugees, especially in the context, I feel, of political instability south of the border in the United States. We are seen as doing really well. Certainly, Canada, and as a long tradition of welcoming refugees and migrants, yes, we have developed in recent years important migration diplomacy efforts, but we are far from being perfect in the field. We can and we should do better. And I see here some very strong, I see here the same ideas through the various presentations. And it's really important to remember that, because I think Canada suffers internationally from this positive image. Not Canada, maybe, not the government for sure, but us working on, working in the field. Sometimes it's hard to be critical of Canada when we go abroad or when we explain to people, that Canada is, yes, has many positive things about migrants and refugees, but we also have our own sets of issues, and we have people who are struggling through the process. And so I think it's really important for an external audience to keep that in mind, and to really keep in mind that it's important to remain critical, even given the resettlement efforts that Canada has deployed in the last year, etc., etc. Coming back to Anthony's presentation, I really enjoy your presentation, Anthony, because it is definitely interesting to hear that there is not one single reference to the Global Compact in court decisions. You highlighted that very clearly. This is not the Global Compact on Refugees, a legally binding instrument. This is not a treaty. It was a document endorsed, in fact, by the UN General Assembly in 2018. And it is not as such a direct source of law for states, because it's not a treaty, and it certainly is not customary law as of today, or not even a codification of customary law in any way. You actually highlighted very well that this is a policy document that cannot be domesticated through ERPA. And what I found really interesting is when you made the comment that this is not a practical instrument as well, at least for decision makers and for lawyers to use. And for me, this is really something important, because, for example, if you look into the UNHCR handbook and guidelines on procedures and criteria for determining a refugee status, they are not legally binding documents as well, but they are practical instruments. They are here to guide decision makers, to guide staff in applying refugee definition, and they have been used by lawyers, they have been used by decision makers. So I think one of the weakness of this instruments, this Global Compact as well, is that this is not a convenient instrument in terms of, it's not a technical instrument, it's not a practical instrument to be used, through in court, for example. So I think that's also what could explain, the fact that, in fact, it has not been much been used in decision-making processes. It's really interesting also when you say that, in fact, it's not also referred to at the policy level. And I really liked your point about why. And just, I completely agree with you. I think this idea that there is an increase, well, this idea, the fact that there is an increase in refugee claim in Canada, and that the government is alarmed by the numbers, as also other presenters said, needs to be qualified once again. Just to give a very quick, as a way of introduction, Germany the same year had close to 145,000 applications from refugee claimants, France 125,000 applications from refugee claimants, and Spain 120,000 applications from refugee claimants. So I think asylum claims are on the rise everywhere, and this is something to keep in mind, and certainly not a reason to continue with this important dichotomy that you described, which is the dichotomy between inland refugee claimants and resettled refugees, and just a point as well on the externalization of migration controls that you were referring to. It's been a long practice in Canada, as you know. It's really not new. Canada has been for several decades an expert, if I may say, almost in pre-inspection regimes, for example, or in training of foreign immigration officers abroad. But certainly I liked the point that you made, which also allowed me to make some connections with other presentations, when you say that there are new tools of management aimed at keeping inland claimants outside of the country, the Safe Third Country Agreement you referred to. And in that point, I think it is interesting to make a connection with Rana's presentation about the closure of borders in the context of the pandemic, again aimed, of course, at preventing spontaneous, if I may say, asylum claimants from coming in. And it's interesting maybe for people who don't know that, to know that the Canadian border is in fact closed to some and open to others, right? Which is also, the logical behind that is a bit hard to follow. So just as an example, the Canadian border remains open to seasonal agricultural migrant workers, because they are seen, and this is exactly how it is stated in the legal documents, as essential workers. But we know that asylum seekers, refugee claimants, work in essential positions. We know that they work in positions that are dangerous, that put them at risk, them and their family. And so the rationale, it is a bit weird, right? As to why keep the border out for them and let others in. It's a bit weird. On the top of it, of course, there are international obligations, as Rana highlighted, that cannot, be escaped even in the global time of pandemic. So it's important to keep that in mind. We need to find a better balance here. Also, the new tools of management, I certainly see and completely follow you. The ineligibility provisions in the legislation, fairly new provisions that exactly again are aimed at preventing or making life much more difficult for inland refugee claimants. The complex administrative requirements that Mary Jo was referring, for me, they fall exactly in the same category, making the life of refugee claimants, inland refugee claimants, more complicated, more difficult. And also, of course, I'm asking you all, because I think we all agree that increasing resettlement is a wonderful thing, that Canada is really playing an important role here. But would you even be ready to say, in fact, that, or to go as far as saying that increasing resettlement is in fact one of those tools in migration management now? We may really ask the question, especially also because, so my understanding is that in 2019, Canada resettled more than 30,000 refugees. 2018, it was around 28,000 refugees. We know that most of those resettled refugees are privately sponsored refugees. So it's really not to actually criticize, really not the initiative of Canada towards resettled refugees. It's an amazing initiative, but I agree that this should not come to the detriment of inland refugee claimants. And this is what is worrying me, because right now there seems to be a discrepancy between the two that continues, right, to increase over the months, over the years. And I'm just wondering what we can do, in fact, to be sure that there is a better understanding and a better consideration of the fact that, as you said, the two are in need of protection, and the protection of one category should not come to the detriment of the other. And this is really something that has been concerning me for really years as well. This dichotomy. How can we really make sure that it does not continue, and how can we reconcile the policies in a better way? And again, resettlement refugees is great, but 2/3 are privately sponsored refugees. So this is also something that needs to be recognized. Mac, when you made the reference to immigration detention, certainly this is a policy that in Canada is and has been for a long time problematic, and that also is not so much known from outside, very often. And I'm pretty sure this is what you also feel when you go abroad, or when you speak to people who are not so familiar with the Canadian regime. Most of the time they are surprised, as to the fact that we are actually holding immigration detainees in provincial jails and so on and so forth. So I'd like to thank you, for having brought that topic in the discussion. I also agree with Rana that it is important to recognize that important efforts have been made, I would say, in the last 3 years to reduce the number of immigration detainees, to improve their immigration condition detentions, and especially aimed at minors. But more must be done. It's definitely not enough. There are huge concerns regarding the fact that we have no limit in terms of immigration detention. The long-term immigration detainees continue, and we know that this is having a major impact on the life of people. Studies have illustrated that in many ways. And just to make a quick connection with the research that I'm currently working on with, on the Vulner project that my colleague Idil was referring to. So if you want, in this research, we actually study the concept of vulnerability, how it is addressed in law, in legal documents, in decisions, but also in legal documents and in policy documents. And of course, we are working on immigration detention, Mac, it's not a surprise. And we of course find out that the treatment of vulnerability is inadequate in Canadian legal documents. It's not properly understood. It's hard to really figure out who is seen as vulnerable and who is not. There are huge variations in documents, but for sure what we'll see is a discrepancy between what the legal document says regarding vulnerable migrants, for example, those who are seen as having mental health issues, and the way they are treated in detention. And so it's also important to keep that in mind. There needs to be, once again, a better conciliation between what is said in the document and what is applied in practice, especially if it does apply, as it does apply to vulnerable migrants. But, again, the whole notion of vulnerability is complicated, and I'm not sure that's the best way of describing migrants who may need other protection needs compared to other migrants. So finally, cessation. I completely follow you on that. I think also is very concerning and not something that is much talked about. So also thank you for bringing that, in the discussion. Federal court's decisions have been very I mean, the interpretation of cessation clauses has not been satisfactory to me in many ways. The decisions have varied a lot, and this is concerning, and also of particular concern, just to add to what you said, is the fact that cessation cases are among the top 3 groups given priority for removal right now, which is also something that is concerning up to a certain way. Mary Jo, I really enjoyed your presentation, which actually provided us with the opportunity to think, how things have changed, how mentalities have evolved, in the decades. How the public openness maybe to newcomers has been modified over the years, and how this could have been modified because we are more familiar now with, encountering other people than we were in the past. When we discussed before, through the email conversation, you had indicated that you would maybe address, this survey. How is it called? Let me see, I can't remember, but there is a survey recently that is
the Environics research.
Exactly. And I found it really interesting as well, so if that's okay with you, just say 2 words about it, because I think it complements your presentation. So just this Environics survey is about the perception of immigrants, the perceptions of Canadians towards immigrants. And it's interesting because in the time of pandemic, we are seeing, in fact, that Canadians have been more open, not less really, to in levels to immigrants, to welcoming immigrants and refugees in levels not recorded in more than 4 decades of Focus Canada surveys. And so they are so that's interesting, and I just would like also to hear your thoughts, Mary, but also, of course, everybody's thoughts about what could lie, in fact, behind this growing public support for immigration and refugees. I have my own ideas, but of course, I'd like to hear your thoughts, because it's interesting to see also when you compare it to, what's going on the policy level. So basically, that's it. I hope I didn't take too much time, but thank you very much. I found that the presentation were were complementing each other really well, and yes, looking forward to the discussion for sure.
Thanks a lot, Delphine, for your comments and for tying together the presentations and some of the themes and issues that emerged from the presenters' talks. I would like to open the floor now. We have around 10 minutes. We're a bit late. I see in the chat 2 questions. I would like to read them. One question from Sujata. To what extent does the Global Compact on Refugees deal with environment, climate change, refugees? And the second question is related to the first one from Melody. And she asks, to what degree does the Global Compact on Refugees reflect women effective participation in agriculture to address food insecurity as basic need? So Melody touches on 3 important issues. One is women's condition, agriculture and food insecurity, and the Global Compact's who would like to answer these questions. Rana had to leave our panel because she has another commitment. who would like to jump in? I've just checked. Oh, please go ahead.
Oh, sorry. I mean, I'm no expert on the Global Compact. There is one reference to climate and environmental issues, and it's in the introduction. So if you're looking at the Global Compact, it's going to be at paragraph 8, and there's a mention that, you know, the Global Compact is in the context of addressing root causes of migration flows and forced migration flows. And there's one line that simply says, while not in themselves causes of refugee movements, climate, environmental degradation, and natural disasters increasingly interact with the drivers of refugee movements. And in the first instance, addressing root causes is the responsibility of countries at the origin of refugee movements. However, et cetera, you know, serious concern international community, need for greater cooperation. So it is there kind of in the deep background of the document about some of the issues that the document is meant to address, but it turns into practical kind of agreements on what steps states are going to take. There's no direct linkage, I think, back to climate change and environmental concerns. It's more of the idea like, you know, we acknowledge that that's part of the driving force and we need to be looking at big long-term solutions, but in the short term, here's how we're going to manage migration flows.
Thanks, Anthony. Anyone else would like to answer these questions? See, women are a part of the so-called vulnerable groups, so women's issues are addressed in both global compacts. But thank you, Anthony, for that. There's another question from Hakan. It has been said that there were few or no references to the GCR in Canada. The Canadian government made 14 pledges in the Global Refugee Forum of December 2019 in many different areas, from asylum capacity building, resettlement to education of refugees. Aren't these referred to at all? Anthony, I think this is a question for you.
I mean, like, I don't have a scientific survey. I can say, like, for example, we use CANLI, which is the public repository of all published immigration and refugee board decisions, as well as judicial reviews of all asylum decisions. So both by the Refugee Board and by the Government Department, Immigration and Refugees Institute of Canada. And there is no reference to the Global Compact in any of those. So that's in terms of decision making. At a policy level, once again, not very scientific, but if you go on Immigration Canada's website and you just type in Global Compact into the search, it's only going to produce 3 hits, and they're mainly speeches from former Minister Hussein back in 2018 when the Global Compact was first announced. So yeah, are there like offline published documents from the department where maybe they're speaking more about it? Possibly. Are there UN documents that Canada's circulating in New York? Possibly. But in terms of like consumption for a domestic audience, both in terms of tribunal and court decisions, and in terms of what documents the Government of Canada is putting on its websites for its own citizens to download and access, we're just not seeing it there.
Thank you, Anthony. Could I ask maybe Joe and Mark also to say a few words about the influence or the visibility of the Global Compact in your daily work?
It's not visible. I think Anthony pinned it right on the head. Like, I think it's not being paid attention to. But Canada unfortunately has a history of ignoring international instruments.
Yeah, I would agree with Anthony that it's almost invisible as an operative policy or a point of reference. If I want to find out what the minister and the department is going to do, I go to the mandate letter that the Prime Minister gives to the Minister of Immigration. And you find all kinds of interesting things in there, some of which, for example, the minister is directed to create a special stream of refugees for human rights workers, writers, journalists, 250 per year. Now, it hasn't been activated, but people like myself, that's where we go to find out what's in the mind of the minister.
Thank you. We have a question from Ngozi who asks, how does the United UNGCR addressed the repatriation of refugees, bearing in mind that some refugees may have intentions to return home. It's unfortunate that Rana had to leave the panel. She would have been the ideal person to answer this question. But who would like to? Yes.
Idil, if you don't mind, just in relation to the other question,
Sure.
I just think also it might be useful to see how it is referenced, because it's one thing to refer to a document, but it all depends, you know, how precisely it is referenced, and you know, we have to. And I'm seeing that sometime, for example, again, with the concept of vulnerability, you know, it's one thing to mention it. It's another one to properly use it. And so I'm not, you know, I think it's great if it can be referenced, but it has to serve a certain purpose. And that's, you know, what I'm thinking also is useful here to keep in mind, if you want.
Yes, absolutely. Thank you, Delphine. And I would like to refer to a talk made by Professor Francois Crépeau a couple of days ago in another webinar, and he said it takes time to these, especially when these kind of soft law instruments to make their way into the policies and then legislation. So it's about changing the culture, the legal culture and political culture within the country, which takes time, sometimes a generation. So let's be optimistic about that. We have a comment from Frank, who says originally in a draft of the UN climate refugees were mentioned as a special new group of refugees whose needs had to be catered for. But the EU opposed this strongly, as they didn't want an additional group of refugees, and they said that climate refugees were anyhow covered by the existing instruments. Thank you, Frank, for this. Frank is our partner, PROTECT partner based in Ghent University. Yeah, this. Yes, Mike, please go ahead.
I just wanted to say, under Canadian immigration and refugee law, climate refugees are not recognized. At best, you could do a humanitarian application, which you're not likely to win. And I also just want to draw the attention to the fact that a lot of climate change is because of the activities of the global north. We use more carbon and more energy than anywhere else in the world. So as with much of refugee law, we create the situation that creates refugees, and then we refuse to help to solve the problem. And as Anthony pointed out with the queue jumpers, we even blame the refugees themselves for trying to gain the same kind of safety, the same kind of economic security that we have for our own families.
Thanks, Mark. Are there any other comments about this discussion in the chat? If that's not the case,
I think the where to put people who face forced migration due to environmental or climate issues is a very difficult problem, legally speaking. And I think the efforts to house them within the Refugee Convention definition have been less than successful. And I think a lot of the energy now is moving towards, say, the ICCPR and provisions that govern, say, the right to life. So I'm sure most people are familiar with the Human Rights Committee. That's the UN tribunal that administers claims under the ICCPR. And earlier this year, they heard a claim from a refugee claimant on the basis that his right to life was being infringed by the rising sea levels. I can't remember which island nation he's from in the Pacific. I think it might have been Kiribati. And he made a claim in New Zealand. It was denied. He took it to the Human Rights Committee. And the Human Rights Committee said, like, look, right now, Kiribati is still above ground or above sea level, but there is the prospect in the future that the rising sea levels there could imperil his right to life under the ICCPR. And then that could be cognizable as a claim to be made against New Zealand at that time. So I think maybe there's other international legal instruments that seem more open to the idea of climate refugees. But we haven't seen that break kind of within the Refugee Convention, where there's a place for climate refugees to move into. And perhaps it is coming, but it will take, I think, some careful legal work and some very good lawyering. But it hasn't happened yet, to my knowledge.
Thank you so much. I would like to thank, first of all, Yona Zufi, who helped me with the organization of this webinar. And I would also like to thank Marie Lund Eide, based in Norway, at the University of Bergen, for her assistance. Thank you, Marie. I would like to thank our speakers, Anthony, Mac, Mary Jo, and Delphine Ranakan as well. Thank you so much for sharing your insights with us. And I wish you a wonderful day on behalf of the Ryerson team of the PROTECT Research Project. I hope we will keep in touch. Have a wonderful weekend. Thanks.